Hello and welcome to Legalbytes. If you're new here, my name is Alita. I'm a lawyer licensed in California and DC, and on this channel, we explain the law one bite at a time. We don't give legal advice, but we do talk about how the law works and try to look into our crystal ball to see how things might turn out. If you're enjoying this on YouTube, we'd love it if you could like the video, subscribe to the channel, share it with friends, all the great YouTube-y stuff. And if you want to listen while out and about, we're now offering our live streams in podcast form where you can leave a rating and review. Links are in the description below, as well as to our clips channel where you can find some of the best clips taken from our live streams. Otherwise, if you want to catch me elsewhere, you can find me on Twitter, Instagram, and Facebook. And if you want to support the channel, you can do so on Locals, Patreon, or by becoming a YouTube member, or by buying some really awesome Legalbytes merch. Again, all links are in the description below. And with that said, let's get into it. Hello, and welcome again. Happy Wednesday, guys. It's Wednesday morning, afternoon, evening. I'm always addressing all of the time zones. But welcome. Either way, wherever you are in the world, welcome. And I'm so happy to see you here. Very happy to see a bunch of people in the chat, a bunch of people waiting. And yeah, I know it's been hot out, right? Kat, that pool did look good, right? Even with the belly flop. Happy to see all of you guys in the chat with some blue hearts. This is great. I love it. Love it. Hello from Nashville, from Omaha. Love seeing where people are from Italy. Shanus, hey, welcome to Bite Club. Happy to have you here as a YouTube member. Really happy to have you here. So yeah, I am wearing my Dodgers gear in honor of Vin Scully. Rest in peace. If you are not a baseball fan, I apologize if you have no idea what I'm talking about, but Vin Scully was the voice of my childhood summers. I grew up a Dodgers fan in Southern California. And even when my family would go to the games at Chavez Ravine, my dad would always bring like a battery operated radio. So we would always hear Vin Scully announcing the games, whether we were in the park or at home or in the car or wherever during the summertime. His voice was everywhere. So I am very sad that he passed away. I mean, it was, he was 93, 94. So, it wasn't exactly unexpected that something like that would happen at some point. But anyway, I'm a big baseball fan, big Dodgers fan, and absolutely a huge, huge fan, and will forever be a huge fan of Vin Scully. I once tweeted at him and he replied, and I was like fangirling for a week. I was like so happy. Anyway, but yeah, that's why I'm wearing the Dodgers gear. But let's get to today's subject. So I'm going to assume that if you are watching this live stream here, you know the background of Marilyn Manson's defamation claim or claims. It's not even defamation. The shorthand of this is typically a defamation claim against Evan Rachel Wood and Illma Gore, but it's really not. I mean, the main portion of his case is actually an intentional infliction of emotional distress case, plus a cause of action for impersonation over the internet, plus a cause of action for computer fraud. So there's plus kind of stuff. But so normally, in order to continue in the litigation, the defense has to file something within a certain amount of time of being served the complaint. And so usually it'll be an answer or a motion to dismiss, or sometimes there will be a special motion to strike, which is an anti-SLAPP motion. And I know I've gotten some folks in the comments to some of my videos recently that have been saying, please, for the love of God, stop explaining what anti-SLAPP is. We know what it is. Just have people refer back to a previous
a previous video so that they can say, but those of us that are following along, we don't need to hear it 5,000 times. And I know after this video, trust me, I'll just have everybody reference back to this one. So, because I get it. I understand that, yeah, you don't necessarily need to hear it 5,000 times, but I also know that there are some people who find anti-SLAPP to be somewhat of a confusing topic. And I understand why, because it's, I don't know, it's kind of strange. Anyway, but let's actually, and before we get into the anti-SLAPP specifically, I'm looking at my notes here. So one of the other topics that's very popular right now is the documents that have recently been unsealed in the Depp v. Heard case. So there were documents that were unsealed and they were made available to the public over the past weekend. And so there's 6,000 pages worth of documents. And so of course, if you saw my live stream from Monday, you are aware that there has been some interesting reporting on these 6,000 pages of documents that were read very, very quickly, presumably. That's the assumption that you have to have. But anyway, I could do a lot of commenting on the reporting, on the tweet threads, on all that kind of stuff. Or I could pull into some of the actual documents themselves and talk about those so that people can actually see what the documents actually do look like and what they actually do reveal and kind of go through those. Let me know in the chat here or in the comments below if you're watching this on the replay, if you are interested in going through some of those documents on this channel as well. Let me know, because if there's an interest, I will happily go through some of this stuff, because there's a lot of interesting stuff for me. Okay. Otherwise, let's get into the anti-SLAPP motions that were filed by Evan Rachel Wood and Illma Gore. So to start, anti-SLAPP motions have a very specific purpose. And I am seeing in the chat now. Sorry. I should always wait like 10 seconds for folks to answer in the chat. But yes, I'm seeing a lot of people saying, go through the documents. Yeah, I know we're all tired of Amber Heard, but okay. So I will probably be going through some of these documents, maybe, but not what has already been gone over by others. Okay. Yep. I'll try to find some stuff that hasn't been gone through yet, and see if there's something interesting to talk about. Or if they have addressed certain documents, but I have a different viewpoint of something. I don't know. Okay. So, cool. Okay. Back to anti-SLAPP. So to start, the anti-SLAPP laws in California were enacted for a very specific purpose. They were supposed to serve as the frontline defense against any action involving petitioning or free speech. In 1992, the California legislature was enacted to address they enacted the code for it to address a disturbing increase in litigation designed to infringe free speech and petitioning activities through the filing of a SLAPP. SLAPP standing for Strategic Litigation Against Public Participation. So as one appellate court put it, the point of the anti-SLAPP statute is that you have a right not to be dragged through the courts because you exercise your constitutional rights. In other words, so you have someone who is just doing their thing, using their constitutional rights, and then all of a sudden they get a civil lawsuit from some other individual. Courts want to prevent that from happening. And so in California, that's exactly why the anti-SLAPP statute was enacted. It was designed specifically to basically prevent this person from being dragged through the lawsuit. It's different from Virginia, where you can have this as an argument as a defense, but it's at the tail end of the litigation that you go through it. So it's kind of like there's almost no point. In California, they say, nope, you argue it first thing. As soon as you get served the complaint, and everything stops. Everything freezes as soon as a motion to a special motion to strike, an anti-SLAPP motion is filed, meaning there's no discovery that's allowed. The plaintiff cannot amend their complaint. They also can't even dismiss their case without there being some sort of penalties. So it's a very powerful statute, and it's really designed to basically say, look, if you're going to file a lawsuit against someone, it cannot be for the purpose of infringing their constitutional rights. So, and in California, it consists of a two-pronged test that has to be completely fulfilled before the defendant can successfully toss out the litigation. First, the defendant bringing the motion has to satisfy the first prong, and then the plaintiff has to fail to meet a certain burden in the second prong. So it's almost like a game of hot potato. First, the defense has to keep the hot potato from just sitting in their lap, toss it over to the other side, and then the plaintiff has to keep the hot potato going and toss it back over. Think of it that way. Now, in the first prong, the defendant has to show that the conduct underlying the plaintiff's cause of action or portions of it arises from the defendant's constitutional right of free speech or petition. This means it's not just speech, but also conduct that helps to advance or assist the speech. So, it's not just going down the street and protesting, but it's maybe gathering the materials to make the signs so that you can go and protest. Think of it like that. Now, there are 4 categories for petitioning the free speech activity and conduct that qualify for the first prong. Those are, so 4 of them. Those are where somebody is either testifying in an oral statement or in a written statement to a legislative, executive, or judicial proceeding. Or the second category is where they make a statement that's made in connection with an issue under consideration or review by a legislative, executive, or judicial body. In other words, if they're saying, hey, we're thinking of changing the law by enacting some kind of a statute here or there, then somebody comes in to make a statement. They make the statement to Congress or to whomever, whatever judicial proceeding or executive body, in favor or not in support of that particular legislation, that is also protected as constitutional activity. The third category is where a person makes a statement that is made in a place open to the public or in a public forum in connection with an issue of public interest. Now, public forum is, generally speaking, fairly broadly construed. It's generally speaking an open public space that's like physically open space, like parks, sidewalks, stuff like that, where somebody is talking about something that is of public interest. In California, it's even more broad than in most other states, because in California, they say that, or there has been case law where courts have said that you can even be in a mall, which is technically owned by a company, but it's a big enough space where people gather and they're able to exchange ideas. And so that is a space that is public enough to be considered a public forum. That's not the case in every single state, but in California it is. And the fourth category is where the defendant engages in conduct in furtherance of the exercise of the constitutional right of free speech in connection with a public issue or an issue of public interest. And so that is probably why where a lot of the conversation is going to be in this particular case, because we're talking about DV issues. We're talking about, these kinds of like relationship issues, Me Too issues, which is it was an issue or a topic of interest, and it kind of still is. It's still a subject that people are talking about, whether it's talking about the Me Too allegations or whether the Me Too movement has gone too far. Like, these are all topics that we are talking about. And we are talking about individuals who are public figures. So I'm not necessarily saying that this automatically, everything involved in this case fits under an issue or topics of public interest, but there are a lot of factors that are involved, and there are arguably a number of factors that Evan Rachel Wood is going to use to argue in this particular case to say that the stuff that she talks about or the conduct involved is in furtherance of her ability to use her constitutional right of free speech. So examples of what this all looks like is testifying in a congressional hearing. That fits under the anti-SLAPP statute. Making allegations in litigation, whether in open court or moving papers or written declarations or more, even if those are false allegations, even if you end up perjuring yourself, technically those don't fall under the anti-SLAPP statute. Someone can go after them for perjury, but not under anti-SLAPP. Another thing that courts have found is that, gathering news for the purposes of reporting on it fits under free speech activity, because reporting the news is free speech, but the gathering process is what facilitates the reporting of the news. So it can be that broad. And courts, generally speaking, are fairly broad in their interpretation of whether or not it fits under the free speech categorization. So the focus in this prong isn't so much on the plaintiff's cause of action, but on the alleged behavior of the defendant that gave rise to what the plaintiff is asserting. Generally speaking, courts are supposed to be pretty broad, like I said, in what they classify as constitutionally protected conduct. In other words, it shouldn't be too hard for the defendant to satisfy this first prong. However, there are some limitations. One is where the plaintiff's claims allege an anti-SLAPP they allege false allegations of criminal conduct. So those are not subject to an anti-SLAPP motion, because California courts have found that, for example, making a false police report is not an act in furtherance of the constitutional right to free speech. Oh, hi, thank you. Okay. Sorry, guys. Okay. So where Marilyn Manson has alleged any kind of criminal activity, even if there is 5-second rule. Thanks, guys. So even if there is some sort of a connection that they try to argue towards free speech or expression or what have you, if Marilyn Manson has alleged some sort of criminal activity there, that's less likely to be considered falling under the anti-SLAPP statute. Okay, that's the first prong. Second prong is, so after the plaintiff or the defendant who's bringing the anti-SLAPP motion, they have to satisfy the first one to say, okay, this activity that I did that is being alleged, that's giving rise to their claims for defamation, intentional infliction of emotional distress, that's all constitutionally protected activity. Then the hot potato goes to the other side for the second prong of the test, and the plaintiff then has to show that they have to meet their own burden after that. So in the second prong, the plaintiff has to show two things. First, he has to show that he has a legally sufficient claim. And second, he has to show that there's a probability that he'll prevail on the claim. He has to show this with admissible evidence. So it's almost as if he has to kind of like in a mini sort of way, kind of put on his case for his causes of action that are being alleged or that are at issue for under this anti-SLAPP motion. So that can put Marilyn Manson on the back foot here, or that can potentially put him in a decent position moving forward if he ends up surviving this motion, this special motion to strike. So, okay, let's get into the actual motions. That's enough background on the two-prong test. Let's get into the actual motions here to see what they actually argue in their motions, to see what's what, right? Okay. So here is Motion number 1, defendant Evan Rachel Wood's notice of special motion to strike and special motion to strike portions of plaintiff's complaint pursuant to Code of Civil Procedure. Now, one of the things to note here is that she doesn't allege every single cause of action that he has is subject to the special motion to strike. So you'll notice that as we go through, but she does go after probably his strongest claims. Okay. Queen v. Missy. Yeah, it is almost like an elevator pitch of his case before he can proceed, because he basically, like, he doesn't have to like prove it to the extent that he's going to need to prove his case at trial. But he does need to show that he has a probability, meaning that there's something there. There's a scintilla of evidence, so to speak, for each element, right? A scintilla or a chinchilla of evidence, as I like to say. And by the way, Anita Zapata, thanks so much for your super chat. It says, any chance you will do a stream with Hogue again? Of course. Oh, heck yeah. Hogue is one of my buddies. In fact, we might be planning some fun streams together with him and a couple other buddies. Stay tuned for that. I'm going to leave that to him to tease that out. But yeah, no, Hogue is one of my best buddies on YouTube for sure. We will be absolutely streaming together at some point. I might actually have him on to talk about Musk or something, just to get me up to speed on that particular case, since he's the expert on that. Alrighty, guys. Okay, so boppity boopity, here we go. And it says here that the date of the hearing is set for December 13th, 2022. That has been moved up, and that is a subject of dispute, which we'll get into later. Maybe in this video, maybe later. But yeah. So far, he has not filed a response to this because he's saying that he needs to have an opportunity to get more information from her. And so that's another argument that we'll be getting into in another one. A little chinchilla de l'évidence. So I apologize to everyone who actually speaks French. I don't, and I know that my French pronunciations are not good. So, okay. We'll go past the notice part. Blah, 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 blah. We'll get into the actual. So we'll go first through the table of contents just to get a little preview of what the arguments are. Okay. So first she goes through her case of facts. This is her version of what she says happened. You know, we've gone through Marilyn Manson's version in his complaint. This is what she says happened from her perspective. She says, first, Warner abuses Wood during their 4-year relationship. And then she says, Wood advocates to extend the statute of limitations for victims of abuse. Third, then she says, Wood names Warner as her abuser. Many other women come forward. Then she says, Warner retaliates against Wood by filing the present lawsuit. So she has framed this lawsuit as just mere retaliation against her for speaking out publicly about issues of domestic violence and about her experiences with domestic violence that come from her relationship with him, according to her allegations. And so she says that she's basically just getting straight up retaliation for her free speech. This is how she's been framing it. Now, number one, she says Warner's allegations and IIED claim, that intentional infliction of emotional distress claim, based on the FBI letter. Then she points to Warner's allegations and IIED claim based on recruiting victims. And then she points to Warner's allegations and claims of defamation per se. So far, she's been talking about IIED and defamation per se. There hasn't been anything about the last two causes of action, but arguably these are the two meatiest ones. The strongest ones from Manson's perspective, if his allegations are true. Then she gets into the legal standard, which of course we mostly went through here. Then she says the IIED claim based on the FBI letter should be stricken. So one of his more, I don't know, you could say one of his crazier claims, about the supposed fake FBI letter. She says that should be stricken, and she says that first, Warner's claim arises from protected activity. And she says first that within that, one example is the filing the FBI letter in a parentage action is protected activity. She says that she filed it as a part of the child custody matter, and that was how that came about. And then she says that the IIED claim arises from Wood's petitioning activity otherwise, and we'll get into those details. And then she says that this is now pointing to the second prong of the test that we just went over. She says Warner cannot establish a probability of prevailing on his claim, saying it's barred by the litigation privilege and it's also meritless. So we'll go through that. And then she goes to the IIED claim based on Wood's communications with other victims. So with the other ladies involved in the Phoenix Rising documentary, et cetera, et cetera. She says that his claim arises from protected activity and that he cannot establish a probability of prevailing on his claim. So once again, pointing to the two-prong test. And then claims based on alleged defamation should be stricken because they come from protected activity. Okay. And he cannot establish a probability of prevailing on his claims. Okay. So, and then she says she's entitled to attorney's fees and costs, which is statutory. So if she does prevail on any of her points here, she does get attorney's fees, reasonable attorney's fees awarded to her from Marilyn Manson. Brian Warner, legally is his name, professionally known as Marilyn Manson. Okay, memorandum of points and authorities. Let's go through the introduction. For years, plaintiff Brian Warner arred and tortured defendant Evan Rachel Wood and threatened retaliation if she told anyone about it. Warner has now made good on those threats by filing the present lawsuit. In it, he seeks to hold Wood liable for defamation and intentional infliction of emotional distress, IIED, based on Wood's decision to publicly name Warner and her abuser and to talk to Warner's other victims. Many of Warner's claims arise from protected activity and all are meritless. They should therefore be stricken under the anti-SLAPP statute. First, Warner asserts an IIED claim based on a declaration filed in a parentage action between Wood and her ex, Jamie Bell. Warner alleges that Wood's declaration attached a purportedly fabricated letter from the FBI, which states that Wood is a key witness in a criminal investigation of a well-known public figure and her safety is of utmost concern. But court filings are the quintessential example of protected activity, and Warner's IIED claim is barred by both the litigation privilege and the First Amendment. It is also meritless, as Wood did not fabricate any FBI letter. Warner is the subject of an FBI investigation, and Warner cannot demonstrate any of the elements required to prevail on a claim for intentional infliction of emotional distress. Now, just pausing real quick on that. So, if the only situation in which she handled, used, touched the FBI letter was during the parentage action, yeah, that would fall very clearly into protected activity for purposes of the anti-SLAPP statute, regardless of whether it was a fabrication. And that includes the act of fabricating it, arguably. But now that she has said that it's also meritless, as Wood did not fabricate the FBI letter, Warner is subject of an FBI investigation, and Warner cannot demonstrate any of the elements required to prevail on a claim for intentional infliction of emotional distress. Arguably, those arguments give him the ability to try to rebut those claims, those arguments. So I've teased the fact that there's another motion on the docket. I've talked about it before, that Marilyn Manson, Brian Warner, I should say, legally his name is Brian Warner. Brian Warner has filed a motion to request limited discovery for purposes of responding to this particular motion, and the motion filed by Illma Gore. And so arguably, by making these these claims in this motion, he's got to be able to meet his own burden, right? So if she's making these factual claims, which means that she's may have opened the door for him to get in there and ask these questions and get evidence for this kind of stuff. So the court still has to decide on whether to allow Brian Warner to get this information, but we're going to go into the arguments at a later date about whether or not his arguments are any good for getting that information. So later date. For now, we'll focus on this. But anyway, just wanted to mention that little aside. Okay, second, Warner's IIED claim, based on Wood's communications with other victims, arises from public or from protected activity and should be stricken. Wood's communications were made in connection with legislative reforms, criminal investigations, and civil litigation, and they concern domestic abuse by a public figure, clearly a matter of public concern. And again, Warner cannot prove the elements of IIED, and his claim is barred by the First Amendment and common interest privilege. Third, Warner asserts IIED and defamation per se claims based on statements purportedly made by another defendant that the actress in Warner's groupie video was underage when the sexual and violent film was made and now is dead. Courts have consistently found that statements about child abuse are protected activity, and that is particularly true here given Warner's celebrity, the defendant's activism, and the ongoing criminal investigations and civil lawsuits, some of which purportedly repeat the statements about groupie. Because Warner cannot demonstrate that Wood made any false statements or that she acted with actual malice, his claims must be stricken. Statement of relevant facts. Okay, so here's where she gets into, this is her framing of what happened. So this is the first time that we get to really see from Evan Rachel Woods what she says happened during her relationship with Brian Warner. Okay. She says, Wood met Warner in 2006 when she was just 18 years old. Warner sought out Wood at a party and told her he was a big fan of her work in 13, a drama where Wood plays a seventh grader dabbling in drugs, sex, and crime. Warner said he wanted to talk to Wood about a project he was working on called Phantasmagoria. By this time, Warner was already a music icon, having taken on the Marilyn Manson persona in 1989. Although the relationship began as a friendship and professional collaboration, one day Warner kissed Wood. Wood was still 18. Warner was 37. Warner and Wood then began a romantic relationship that continued on and off until 2010. Because Warner and Wood are both celebrities, their relationship garnered a great deal of public attention. What started out as a seemingly loving relationship became increasingly abusive over time. During the course of the relationship, Warner abused Wood by, among other things, awing her, torturing her, tying her up, beating her, shocking sensitive parts of her body, threatening her life, blackmailing her, hacking into her accounts, and isolating her from friends and family. Finally, in 2010, Wood found the courage to leave Warner for good. It is interesting that she doesn't mention that they were engaged. Not to say that she needs to, but it's just interesting that she left that out. Part B, Wood advocates to extend the statute of limitations for victims of abuse. Although she escaped from the relationship with Warner in 2010, coming to terms with the profound effects of years of physical and emotional abuse and feeling safe enough to talk about it despite threats of retaliation took much longer. Wood did not speak about the abuse until 2016, and she was not ready to publicly name Warner as her abuser until years later. Once Wood began speaking about the abuse, she connected with other activists. In February 2018, Wood testified before the U.S. Congress to promote implementation of the 2016 Sexual Assault Survivors Bill of Rights across the country. Wood testified to some of the horrific details of the abuse she suffered, but she was not yet ready to name Warner as her abuser. Nevertheless, after testifying before Congress, Wood was contacted by other women who claimed to have experienced similar abuse inflicted by Warner. So she says, it's interesting because this is a factual dispute right here. Brian Warner has said that she sought out other people either her or Illma Gore, or Illma Gore or her through Illma Gore, one way or another. They were conspiring together to reach out and find women to join in on a conspiracy to come out with false allegations against him. What she's saying here is that she says that she spoke out, she went to Congress, she went here, she went there, she was testifying, advocating for changing the laws, and that these other women came out of the woodwork and reached out to her. It could be both, right? It could be a mix of those. But maybe a few women reached out to her, and then she said, oh, maybe there are more people, and then reached out to more people individually. Could be. We are in the beginning of this litigation, so we'll find out. After learning that she was not Warner's only victim, Wood approached a prominent attorney with evidence of Warner's abuse, but she learned that the statute of limitations for Wood's claims against Warner had already expired. Shocked that there was no longer a remedy for horrendous crimes. Wait a minute, sorry. Shocked that there was no longer a remedy for the horrendous crimes committed against her, Wood began advocating to extend the statute of limitations for survivors of domestic violence. In April 2019, Wood testified again, this time before the California Senate, in support of the Phoenix Act, a bill that passed and extended the statute of limitations for charges of domestic violence. Once again, Wood testified to the type of abuse she had suffered, but declined to name Warner. Interesting to note that she doesn't name the lawyer in this, because she does in her declaration. Let me see if I can find it here. Sorry, guys. I thought I had it in here, so I didn't pull it up. And I just want to double check before I say it, just to make sure. Okay, yeah. I don't want to move the screen from this, so I'm gonna keep this here. So I'll just read to you guys a paragraph or two from her declaration, where she says her declaration that is in support of this motion. She says in paragraph 11 of her declaration, around that time, I approached attorney Gloria Allred with evidence of Mr. Warner's abuse. However, by this time, several years had passed since I left the relationship with Mr. Warner, and I was told that the statute of limitations for my claims against Mr. Warner had already expired. I was surprised and shocked to learn that there was no longer a remedy for crimes committed against me. It is interesting because Gloria Allred has taken on a number of cases. I can't remember the specific names of individuals that she has taken, but it's interesting to me that Gloria Allred didn't take her case after the laws had changed, or to defend her in this particular case. That doesn't mean anything necessarily about the merit of her claims or the merit of Marilyn Manson's claims. I just find that personally interesting, that she didn't see this case as one that she wanted to represent. Gloria Allred also may have also retired at this point. So who knows? I haven't double checked on what she's been doing. So, okay. Now part C. Wood names Warner as her abuser. Many other women come forward. On February 1st, 2021, Wood identified Warner as her abuser in an Instagram post stating, "The name of my abuser is Brian Warner, also known to the world as Marilyn Manson. He started grooming me when I was a teenager and horrifically abused me for years. I was brainwashed and manipulated into submission. I am done living in fear of retaliation, slander, or blackmail. I am here to expose this dangerous man and call out the many industries that have enabled him before he ruins any more lives. I stand with the many victims who will no longer be silent." So one of the things is that she says that he was grooming her when she did say, now call me nitpicky, but my understanding is that grooming is referring to where someone who is over 18 starts a sort of a relationship that's not yet romantic with someone who is under 18 for the purposes of sort of grooming them, of bringing them eventually into a relationship that is romantic as soon as they turn 18. In this particular case, you know, not to say that we should have the expectation that everyone always uses the very precise definition of terms, because, you know, I slip up and say things that I don't necessarily mean, or in a way that I don't exactly mean. It's not exactly precise from time to time. Everyone does, but she does use the word grooming when she has said it. It is notable that she has said earlier in this motion specifically that she was 18 when they met. So technically, my understanding is that doesn't meet the definition of grooming. That's one portion of this whole paragraph here, though, that she posted on Instagram. Okay. And that doesn't necessarily mean, you know, even if her definition of grooming is different than what I think it is, or what is commonly thought of as as grooming. I don't know if that's accurate for everyone else, or I don't know. But anyway, but that doesn't necessarily mean that these other allegations are true or untrue. It's just something that I'm noting as we're moving forward. Okay, so then she goes on. Many other women have also accused Warner of abuse. Both the LA County Sheriff's Department and the FBI have launched investigations of Warner, and Wood has provided evidence in connection with them. At least 4 women have also filed civil lawsuits against Warner based on his abuse. So I know that this is also disputed by the Manson camp. And especially the FBI investigation aspect. And I know that there also can be different interpretations of what it means to be under investigation by the FBI, because there are different levels of investigation that the FBI will do of different people based on certain claims that they get. And okay, and also going back on the 18-year age thing, I do agree. 18 is a very young and impressionable age. I do see that in the chat, and I do 100% agree. 18 is not some magical year at which someone suddenly becomes like fully an adult and ready to handle the whole world all at once. We're like when they were 17 and 364 days old that they weren't, you know. It's not some sort of like magical age like that. But the fact of the matter is that there is a legal difference between 17 and 18. There is. So that's one of the realities that cases like this may have to deal with. Maybe, I don't know. How much of an issue will it be in this case? We'll see as we continue on. Yeah, and I do see in the chat folks saying that she had also dated other older men before him. That's also an interesting note, if true. So if that is the case, that's highly relevant for her claims about grooming, for her claims about the age difference. So okay. So anyway, let's move on. Paragraph or part D. Warner retaliates against Wood by filing the present lawsuit. On March 2nd, 2022, Warner retaliated by filing the present lawsuit against Wood and another woman who worked on the Phoenix Act, Illma Gore. Warner filed the lawsuit less than 2 weeks before the premiere of the HBO documentary Phoenix Rising, which chronicles Wood's experience as a domestic violence survivor and activist. In the complaint, Warner asserts causes of action for 1, intentional infliction of emotional distress, 2, defamation per se. 3, violation of the Comprehensive Computer Data and Access Fraud Act. And 4, impersonation over the internet. Warner's IIED claim cause of action includes 5 claims based on the conduct alleged in paragraph 63, subdivisions A through E. This motion seeks to strike Warner's IIED claims based on the conduct alleged in paragraph 63, subdivisions C, D, and E, and Warner's cause of action for defamation per se. Part 1. Warner's allegations and IIED claim based on the FBI letter. Warner alleges that Wood and Gore, quote, impersonated a federal agent by creating and distributing a fictitious letter, unquote. The FBI letter states, please be advised that Ms. Evan Rachel Wood is a key witness in connection to a criminal investigation in Los Angeles, California, involving an internal and well-known public figure. The safety of Ms. Wood, her family, other victims, and of their families are of the utmost concern during this time. Warner is not specifically named. The complaint alleges that Wood submitted the FBI letter in a California custody proceeding, using it as supposed evidence for why she should be able to move her son to Tennessee. The complaint also quotes from Wood's confidential declaration in the parentage action, alleging that the following statements by Wood were untrue. That she was advised by criminal investigators that my and my family's safety was at risk, and to punctuate the seriousness of the situation, I was provided with a correspondence from a representative of the Federal Violent Crimes Department from the FBI. The complaint does not specifically allege that Wood distributed the FBI letter other than in the custody proceedings. I thought it did. I may need to go back to the complaint because I thought that it did. She also allegedly gave it to the other woman that she was talking to for purposes of talking about their claims against Marilyn Manson, was my understanding, according to the complaint at least. Okay, Warner's IIED cause of action includes a claim based on Wood and Gore purportedly falsifying correspondence from a fictitious federal agent claiming that there was concern for the safety of Wood, other alleged victims of Warner and their families, as well as an ongoing federal criminal investigation targeting Warner. Yeah, they can get there through implication, though. Yeah, I think, like, even if the letter doesn't specifically name him, if there's enough context there that it's relatively, you can piece together that it's about him, and there's other context, there's other circumstantial evidence that you can piece together for that, I think that's probably enough. Okay. Part 2, they say Warner's allegations and IIED claims based on recruiting victims. The complaint alleges a separate IIED claim based on Wood and Gore purportedly recruiting, coordinating, and pressuring multiple women to make false accusations against Warner and to be part of their film project. Specifically, Warner alleges that Wood and Gore used their work advocating for the Phoenix Act and in connection with the Phoenix Rising documentary to recruit, coordinate, and pressure women who had been linked to Warner to make false accusations of abuse against him. According to the complaint, Wood and Gore coordinated allegations and devised the specific buzzwords, phrases, and talking points that prospective accusers would use when they gave interviews or posted their stories on social media. The complaint further alleges that Gore used Wood's status as a famous actress and the criminal investigation of Warner to get potential accusers to meet and coordinate allegations which were filmed for Phoenix Rising. Warner alleges that purportedly false statements made to prospective accusers have been repeated in the civil lawsuits filed against him. Okay. And then they point to Warner's allegations and claims of defamation per se. The complaint alleges an IIED claim and a cause of action for defamation per se based on purported statements by Gore about Warner's movie Groupie. Specifically, Warner alleges that Gore told unnamed third parties that during the filming of Groupie, the actress in the video was a minor and that the actress was dead. Warner contends that Gore understood these statements to mean that Warner's role in the making of Groupie, e.g. as child prawn, was criminal, adding that Gore stated that Groupie was evidence of a felony and that Warner would be indicted as a result. Warner does not attribute any statements about Groupie to Wood, but alleges that Wood condoned and encouraged Gore to promulgate defamatory falsehoods about Warner. So that part, which they mentioned here about the evidence of a felony and that Warner would be indicted as a result, that may cause some trouble for that particular statement falling under anti-SLAPP for both Evan Rachel Wood and for Illma Gore. But we'll get into more of that in a bit. Okay. Legal standard. Under the anti-SLAPP statute, any cause of action against a person arising from any act of that person in furtherance of that person's right of petitioner free speech in connection with the public issue shall be subject to a special motion to strike unless the court determines that the plaintiff has established that there is a probability that the plaintiff will prevail in the claim. So, again, the two-prong test, right? First, she has to show that it is that the activity that has been alleged falls under some sort of a constitutional right. And number two, then in order for her to win, he has to not be able to show that he has a probability to prevail on the claim. The legislature has mandated that the statute shall be construed broadly. An anti-SLAPP motion need not attack an entire pleaded cause of action. Mixed causes of action, those that include both claims based on protected activity and claims based on unprotected activity, are analyzed as follows. Basically, without going into all of that whole paragraph, I'll paraphrase for you guys. The portions that are deemed to fall under anti-SLAPP fall under anti-SLAPP, and then the other portions get disregarded by the anti-SLAPP motion. In other words, they would automatically survive the motion. In other words, courts should analyze each claim for relief, each act or set of acts supplying a basis for relief, of which there may be several in a single pleaded cause of action, to determine whether the acts are protected, and if so, whether the claim they give rise to has the requisite degree of merit to survive the motion. If the plaintiff cannot demonstrate that a claim for relief based on protected activity has merit, those particular allegations will be stricken. Applying these steps here leads to only one conclusion. The allegations and claims for relief based on the FBI letter, Wood's communications with other victims, and the alleged defamation must be stricken. Okay. And here's why they say that the IIED claim based on the FBI letter should be stricken. Let's see if it's good enough. Okay. Part A. Warner's claim arises from protected activity. So this is prong one of the anti-SLAPP test. Under the first step, Wood need only show that Warner's claims arise, at least in part, from Wood's acts in furtherance of her right of petition or free speech. Wood meets her burden by demonstrating that the act underlying the plaintiff's cause fits one of the categories spelled out in section 425.16, subdivision E. And that's the four categories that I listed earlier. Part 1 under Part A. Filing the FBI letter in a parentage action is protected activity. Here, Warner's IIED claim is based on a purportedly forged letter attached to Wood's declaration in a parentage action between Wood and Jamie Bell. Court filings are a textbook example of protected activity. That is true. I will say that is 100% true. Section 425.16, subdivision E, the anti-SLAPP statute, defines an act in furtherance of a person's right of petition or free speech to include both Any written or oral statement or writing made before a legislative, executive, or judicial proceeding or any other official proceeding authorized by law. And 2, any written or oral statement or writing made in connection with an issue under consideration or review by a legislative, executive, or judicial body or any other official proceeding authorized by law. So, in other words, a judicial proceeding gets you there. All petition-related acts performed by parties or their attorneys in judicial proceedings are per se protected. By protecting all petitioning conduct, the legislature created a reasonable, bright-line test applicable to a large class of potential Section 425.16 motions. Moreover, courts have consistently held that filings in family law proceedings are protected activity. And then they cite to Vivian v. LaBroucherie, where they say the claims arising from family law action arose from protected activity. Yeah, that makes sense. And then another one, granting special motion to strike claims arising from request for restraining order. The FBI letter and any alleged communications between Wood and Warner's other victims about the FBI letter or its contents also constitute protected activity for the reasons discussed in Section 5A infra. For example, e.g., as statements in connection with official proceedings and in connection with matters of public interest. So the FBI letter, any claims based on her use of the FBI letter for purposes of the litigation, for purposes of the parentage action, yes, I would agree. That would be protected activity, in which case that would meet the first prong, right? That doesn't automatically mean she wins the anti-SLAPP motion argument, but that would meet the first prong very clearly. But if she is also using it elsewhere that do not fall under the anti-SLAPP activity, then she would fail on that particular cause of action for the FBI letter. So in other words, you can't just say, well, I used this communication or I used this statement in litigation and then I used it in 20 other places. But because I used it in that one instance of litigation, that therefore it's protected in all of the other places. I don't think it works that way. That's not my understanding based on the research that I've done on anti-SLAPP. And to answer Solo Dave and to answer, but does it count that the letter is fake? It does count. So if the letter is fake and she used it for the parentage action only, let's say it doesn't show up anywhere else in the world and she used it only for the parentage action. And let's say that she definitely drafted it herself, et cetera, then she would have some issues of possible perjury charges, but not anti-SLAPP. So because of the fact that it would be the creation of that document arguably would be in furtherance of her free speech right to petition, or for her First Amendment right to petition the government. So that's what litigation is all about. So let me also, did I get Lena Palmquist earlier? Did I welcome you to Bike Club yet? I apologize if I didn't. Welcome to Bike Club. I'm happy that you're here as a YouTube member. Also, Tracy Fagan, thanks so much for the super chat. It says, why is there SLPP? Isn't that up to a jury? No, anti-SLAPP is actually a strictly legal argument. So it's up to the judge. These are all issues of law, not fact. So it's up to the finder of law, which is a judge, as opposed to a jury, which is a finder of fact. Secret Mix Squirrel, thanks so much for the super chat. What are you doing super chatting me? You should be resting. I hope you're feeling well. I hope you are resting. But he said, hey, you watching, hit that like button, please. Thank you so much for that. Yeah, if you guys are enjoying this, you are getting value out of this, I would I'd love it if you guys would hit the like button. Okay. Alrighty. Oh, and then Tracy Fagan, thanks so much for the super chat. What if Jamie gave it to Marilyn Manson? Then that still would be covered under anti-SLAPP, I think. I think that would still be covered under anti-SLAPP because it's not her distributing it elsewhere. She's only used it for the purposes of the litigation. But thank you for the super chat. Okay. Part 2, the IIED claim arises from Wood's petitioning activity. Warner's IIED claim based on the FBI letter arises from Wood's petitioning activity. Indeed, the complaint specifically references the submission of the FBI letter in a California custody proceeding and quotes from Wood's declaration attaching the letter. Okay, but if she also used it elsewhere, then the analysis goes further. Warner may argue that his IIED claim does not arise from Wood's filing of the FBI letter, but rather from the alleged fabrication of the letter. Any such argument would fail. First, whether or not Warner's allegations about the fabrication of the letter are true, and they are not, the act of forging the letter cannot cause distress to someone unaware of its existence. It is the FBI letter's publication through the court filing, not its creation, that would cause any purported distress. Moreover, the act of preparing documents to file in court, even if perjurious or forged, qualifies as privileged petitioning activity. Otherwise, every defamation claim based on allegedly false statement in a declaration would fall outside of the anti-SLAPP protection. That is clearly not the law. I mean, that is correct that the creation of the document, like I said, would fall under the anti-SLAPP statute. There's other argument though about him not knowing about it until it's been published in the through the court system, through the court filing. I don't think that's what he alleged though. I don't think he, and maybe I'm mistaken. It's been a minute since I looked at that. But my understanding was that it was alleged that the emotional distress that he suffered was in the conspiracy that was involved in that, not through any sort of court filing. Hey, Kurt. Hey, in civil law. Happy to see you in the chat. Part B, Warner cannot establish a probability of prevailing on his claim. Because Wood has demonstrated that the IIED claim based on the FBI letter arises from protected activity, the burden shifts to Warner to establish by competent and admissible evidence a probability of prevailing on his claims at trial. Warner cannot meet his burden. First, the claim is barred by the litigation privilege. Warner cannot establish a probability of prevailing on his IIED claim based on the FBI letter because it is barred by the litigation privilege. They cite to Digerati Holdings, LLC, v. Young Money Entertainment, LLC, saying a plaintiff cannot establish a probability of prevailing if the litigation privilege precludes the defendant's liability on the claim. That would be true. That would be true because that would be a complete bar to it. It would. If it falls under the litigation privilege. So, but let's continue on to see what they have to say about the litigation privilege. The litigation privilege applies to any communication made in judicial, quasi-judicial proceedings by litigants or other participants authorized by law to achieve the objects of the litigation and that have some connection or logical relation to the action. Communications with some relation to judicial proceedings are absolutely immune from tort liability by the litigation privilege. To effect its purposes, the litigation privilege is absolute and applies regardless of malice and has been given broad application. Put another way, application of the privilege does not depend on the publisher's motives, morals, ethics, or intent. Any doubt about whether the privilege applies is resolved in favor of applying it. Here, Wood's declaration attaching the FBI letter was filed in a parentage action. The declaration and its exhibits are clearly communications with some relation to judicial proceedings. Thus, they are absolutely immune from tort liability by the litigation privilege. This is true regardless of whether Wood forged the FBI letter, she did not, or made knowingly false statements in her declaration, again, she did not. The privilege has been applied specifically in the context of claims alleging the filing of false or perjurious testimony or declarations. Citing to Ken v. Stennis, where it says IIED claim based on filing false police reports and prosecuting civil harassment petitions was barred by the litigation privilege. And then they cite to Pollock v. University of Southern California, regardless of whether declaration is perjurious, it functions as written testimony and is exactly the sort of communication the privilege is designed to protect. And then they also cite to Carden v. Getzoff, and they say claims for infliction of emotional distress based on false evidence submitted in dissolution proceedings were barred by the litigation privilege. Finally, Pettit v. Levy, preparing and presenting false documents is equivalent to the preparation and presentation of false testimony. Since there is no exception to the privilege when the testimony is perjured by a parity of reasoning, no exception should apply to the preparation and presentation of false documentary evidence. So that would be true if what he was alleging was that the FBI letter only came about in the course of those proceedings. That is not what he has alleged, from my recollection. Part 2, the claim is also meritless. Even if the litigation privilege did not apply, Warner could not meet his burden of demonstrating a probability of prevailing on the merits. The elements of IIED are 1, outrageous conduct by the defendant, 2, intention to cause or reckless disregard of probability of causing emotional distress, 3, severe emotional suffering, and 4, actual and proximate causation of the emotional distress. Warner cannot meet his burden with respect to any element, and his claim is barred by the First Amendment. First, Wood's conduct was not outrageous. Contrary to the allegations in the complaint, Wood did not impersonate an FBI agent or forge a fictitious letter. Rather, when Wood received a copy of the FBI letter and when she filed it in court, Wood believed it to be authentic. Wood had every reason to believe that in the FBI letter's authenticity because Wood has provided evidence to the FBI and the LA County Sheriff's Office in connection with investigations of Warner and fears for her safety based on Warner's threats and past conduct. Likewise, Wood did not knowingly make any false statements in her declaration. In short, there was no impersonation, no forgery, and no perjury. Wood's actual conduct, explaining to the court why she fears living close to a man who has tortured, and threatened her, is in no way outrageous. It is Warner who acted outrageously. Well, okay, but playing devil's advocate here, those are all disputed facts here. He has alleged that she did all of those things. And even if she says that she didn't, these are definitely disputed facts that can be up to interpretation. And if there's a gray area, that would arguably go in his favor because he's the one that has alleged it. So that's, to me, this is not exactly the most compelling argument for going to the first element of intentional infliction of emotional distress. But what does she say about element 2? Element number 2. Second, Warner cannot meet his burden to prove that Wood filed the FBI letter with an intent to cause Warner emotional distress. Wood did not file the FBI letter to cause Warner distress, but rather to explain to the court why living in close proximity to Warner was distressing to her. Indeed, because the FBI letter was submitted in connection with parentage action to which Warner is not a party, Wood did not know that Warner would ever receive a copy of the letter. Documents and records filed in parentage actions are not publicly available and are only subject to inspection in exceptional cases upon an order of the court for good cause shown. Warner apparently became aware of the FBI letter because it was leaked to the press. Question is then, who leaked it to the press? We have seen that there are ways, we have seen in the Deputy Heard trial that there are ways of proving that that can be a particular individual. But Wood did not distribute the FBI letter outside of the custody dispute, did not provide it to Warner, and did not leak it to the press. Thus, Warner cannot prove that Wood intended to cause Warner distress by filing the letter. Just because she says it doesn't happen doesn't mean that he can't prove that it did. There are other ways of proving it. Number one, by deposing her. Number two, by asking for information, deposing other people, deposing folks at the Daily Mail, or getting discovery requests to folks at the Daily Mail, about their process, for example, for how they got that, and some ways of showing who gave that to them. Who gave the FBI letter to them? Was it Jamie Bell or Jamie Bell's side of the litigation, or was it Evan Rachel Wood when that was made public? Because if she did make that public, then an argument can definitely be made that would create a gray area that would be up to interpretation about her intent in leaking that out to the Daily Mail. If that can be reasonably be shown. And anytime there is a certain fact that is up to interpretation, courts are going to say, that's a jury issue. We're not dismissing. So up to interpretation, some sort of a gray area. The party that is trying to dismiss the action or dismiss the cause of action is going to lose that particular motion. Okay. So, but like I said, just because she says that she didn't leak it doesn't mean that he cannot prove it. So there are other ways of potentially proving it. Third, so what does she have to say about the third cause of action for IIED? Third, Warner cannot meet his burden to demonstrate severe emotional distress. Indeed, apart from the conclusory allegation that Warner has suffered severe emotional distress, the complaint does not include any specific allegations or details about the purported emotional distress Warner claims to have suffered. And this also goes to question by Tiny Trifle here in the chat. It says, actually, to argue emotional distress, does Marilyn Manson have to prove PTSD or something? No. He doesn't have to allege PTSD. He doesn't have to prove PTSD. He has to show that he's been somehow emotionally harmed. That can be in various ways. It could be in, him needing to get therapy to talk about it. It could be in also, it affecting his everyday life, affecting his ability to go to work, affecting, doing all kinds of things in their normal life. So Toshiro, to answer your question, a psychiatric report could help. I wouldn't say that it's necessary unless he puts that specifically out there, that he has certain specific issues that he has. That's one of the subjects that's come up in the Deputy Heard situation recently, right? Because folks have taken the unsealed documents that talk about how Johnny Depp argued in motion papers about that he didn't allege a specific injury, right? So therefore, he shouldn't be subject to an independent medical examination. Unlike Amber Heard, who had alleged that she had PTSD as a result of her relationship with Johnny Depp, or a result of the defamation, I should say, and that therefore, she had some specific psychological harms that she had alleged. He didn't allege anything like that. Doesn't mean that he didn't allege emotional harms or other harms as a result of Amber Heard's actions, but because his allegations about the harms were much more generalized, they didn't have to go into those sort of um specific points to rebut those claims, essentially. So here, they're saying that he doesn't include any specific allegations or details about purported emotional distress. But what he has alleged, in my opinion, is enough to survive a motion to dismiss. So, okay, like, points for making the argument. They have to make the argument, but I think that this particular claim, this particular point, this argument is not convincing. If they somehow had some sort of smoking gun evidence where he walked around and said, life has never been better, that could be different, maybe. But even then, that would arguably just create, like I said, a gray area, in which case that would go to a jury, in which case this motion would not necessarily win. Okay. Fourth. So the fourth cause of action, or the fourth element of IIED, is what they're pointing to. Fourth, Warner cannot meet his burden to prove that any distress he claims to have suffered was caused by Wood filing the FBI letter. If Warner has suffered distress, it is not because of a perfunctory letter, which does not mention Warner by name, was filed in a confidential parentage action. Rather, it is because Warner committed horrific criminal acts against numerous women and is the subject of ongoing criminal investigations and civil lawsuits. This particular argument is not convincing to me. Where they have already pointed to the Daily Mail article, if there is a possibility that was leaked by her, if they can get some sort of evidence that she leaked that to the Daily Mail, that creates a gray area, right? That creates enough of a gray area that this litigation would continue. So just because she says that, he did terrible things, and her, her initial use of this, or her use of this FBI letter, was in the litigation of the parentage action, which is supposed to be confidential. Fact of the matter is, if there's evidence, like I said, if there's evidence of that, of her somehow leaking that to the Daily Mail, she's a little screwed on this argument. I'm not going to lie. Finally, a quote unquote public figure like Warner may not recover for the tort of intentional infliction of emotional distress based on the publication of a statement about him without showing that the publication contains a false statement of fact. The FBI letter states, 1, Wood is a key witness in connection to a criminal investigation involving an international and well-known public figure, and 2, the safety of Wood, other victims, and their families is of the utmost concern. Both statements are true, and the second statement is not an actionable statement of fact. Thus, Warner's claim based on the FBI letter is barred by the First Amendment. So this, however, is disputed. This is disputed by Marilyn Manson's side, right? Because, spoiler alert about the declarations coming from his motion on the discovery issue for anti-SLAPP. He said he attaches a declaration of one of his attorneys that has spoken with the FBI agent whose name is used on that letter, who apparently said to the attorney, indicated to them that none of that is correct. So that the FBI letter is not real. She never sent it out. The department that it says that it refers to does not actually exist in the FBI. And apparently that Brian Warner is not under investigation by the FBI. So that's one of the reasons why they want to have a deposition of that particular FBI agent. And so, yeah. So like I said, all of this is disputed. And where that's disputed, there's a possibility of him possibly prevailing on this particular point. Okay. But let's turn to part 5. The IIED claim based on Wood's communications with other victims should be stricken. So this is where she's talking to the other ladies. A, Warner's claim arises from protected activity. In addition to speech and petitioning activities in connection with legislative, executive, and judicial proceedings, protected activity also includes any written or oral statement or writing made in a place open to the public or a public forum in connection with an issue of public interest, and any other conduct in furtherance of the exercise of the constitutional right of petition or the constitutional right of free speech in connection with a public issue or an issue of public interest. Warner asserts an IIED claim based on Wood and Gore purportedly recruiting, coordinating, and pressuring multiple women to make false accusations against Warner and to be part of their film project. This claim arises from protected activity for several reasons. Domestic violence. The accusations Warner references are statements made by Wood and many other victims accusing Warner of domestic violence and abuse. These statements were made on social media and press interviews and in a survivors meeting filmed for Phoenix Rising. Courts have consistently held that communications regarding domestic violence and sexual abuse are a matter of public interest. Citing to Sipple v. Foundation for National Progress, where they say domestic violence is a matter of public interest. Cross v. Cooper, where they say protecting people from sex offenders is a matter of public interest. MG v. Time Warner Inc., where they say child molestation is a matter of public interest. Public interest in allegations of sexual assault and domestic violence has only increased in the wake of the Me Too movement. And survivors of abuse must be able to speak to other survivors of abuse without the fear of being sued. Possibly. They might have that. They might. But statements made on social media and press interviews, I am not so sure about those particular statements that those would fall under this umbrella for prong number 1. I think perhaps the group meetings where they all come together and they talk about what they went through, because that could be possibly in furtherance of them saying, hey, we need to, make our Okay. Now you should hear me. I know. I saw a notification that my mic got unplugged. So all right, got it fixed. Thanks, guys. So I don't know what the last thing you guys heard me say was, but basically, wrong mic now. Dang it. Why does it always do this? Hang on. Okay. This should be better. You're Elaine. Yeah, for some reason, my there's like a loose wire in my mic for some reason, and then when it randomly unplugs, then I plug it back in. StreamYard wants to go through my earbuds automatically. So, okay. So, alrighty. Cool. We got it. Mike Elaine, turn your mic on. Keep the mic on, Elaine. All right. It was an Elaine moment. That's fine. Okay. So, but I'm not sure what the last thing you guys heard me say was, but basically my point was that the statements that were made on social media and press interviews, I'm not so sure that those are going to fall under protected activity. Survivors meetings, as they call it, for filmed for Phoenix Rising, possibly. So but we'll see. That's it's an interesting argument because of the fact that when we're talking about public issues, we are talking about Marilyn Manson, who is a public figure. So that tends to give a bit of a bump up in these kinds of conversations about whether or not it is a matter of public interest. Then we also have the Me Too conversation that has been happening for the last several years as well. That is also something that would give these kinds of accusations a bit of a bump up as to whether it is considered a bump up to a public interest issue versus a private interest issue. So, okay. Then we're getting into criminal investigation. Warner alleges that Wood and Gore enticed potential accusers to allege abuse by suggesting that they were already amassing evidence for a claimed ongoing criminal investigation of Warner. Warner is the subject of criminal investigations by the FBI and LA County Sheriff's Department. Statements in anticipation of or in connection with criminal investigation are protected activity. Citing to Terry V. Davis Community Church, where they said meetings regarding a matter referred to police were protected activity, even though police concluded there was insufficient evidence of a crime. They cite to Dwight R. v. Christie B., where they say alleged conspiracy to falsify evidence that plaintiff was molesting a minor, an alleged improper coaching of a minor, were protected activity as act preparatory or to or in anticipation of official proceedings. Okay. However, where there's an allegation that the underlying activity was making a false criminal accusation is not protected under the law. Okay. But, okay, possibly. I mean, this is like, so going back to their specific argument here, though, if they're saying that they were somehow in the process of helping to gather evidence for these criminal investigations, then sure, this could be protected activity. These meetings with these other women, these communications with these other women. Again, though, this is all the more reason why I think that Brian Warner may have a case for having some limited discovery here to talk to them about what information they actually had from the FBI, from LA County Sheriff's Department. What communications do they have? What were they relying that on? What information were they trying to gather for those purposes from the police department, from those individual women? Why are they gathering information for these investigations when they could have just been giving names and contact information to the police, to the FBI, for them to gather information? Like, why would Wood and Gore be deputized in this situation to do that for them? I'm not so sure that I'm convinced by this particular argument for those purposes or for those reasons. Okay. All right, next part. Legislation. Warner also alleges that Wood and Gore used the Phoenix Act and Wood's work as an activist to recruit and attract potential accusers. Speech and petitioning activities in connection with issues under legislative review, such as the Phoenix Act and other legislative reforms affecting survivors of domestic violence, are protected activity under subdivisions, blah, blah, blah. Okay, yes, true. But that doesn't necessarily mean if the alleged activity comes after the constitutionally protected activity, right? Like, so she's saying that the allegation by Brian Warner here is that She had this activist activity, and then she used that to then lure in or hook in these other women to make these false statements, right? The false statements are not in furtherance, arguably in furtherance of the constitutionally protected activity, the activism, right? The activism would have come first. So how can it be in furtherance of that activist activity if it came afterwards, right? So I'm not convinced by this argument either. Public figure. The fact that Wood and the other victims are accusing a world famous celebrity of domestic violence heightens the public interest in the accusations. That is true. It is axiomatic that speech regarding a public figure is more likely to be deemed a matter of public interest. That is also true. Citing to filmon.com Inc., the Double Verify Inc., where they say whether the subject of the speech or activity was a person or entity in the public eye is one of the primary considerations in determining what constitutes a matter of public interest. And they cite to Hall v. Time Warner Inc., where they say Marlon Brando's celebrity rendered decisions about the distribution of his assets an issue of public interest. And then they cite again to Sipple, saying allegations of domestic violence against prominent media strategists were a matter of public interest. Now, that one is probably the most on the nose for this particular case here, right? Because this is kind of, it's at least related to this particular case. However, it is notable that the accusations that Marilyn Manson has made here against Evan Rachel Wood and Illma Gore are not specifically for the domestic violence accusations, but rather for these other activities of conspiracy to bring in these other women, drafting up and sending out a fake FBI letter, leaking it to the press, etc. So, but the overall point here about the fact that he's a public figure bumps it up into it's a factor in favor of this being a public interest issue as opposed to a private interest issue is true. So, litigation. At least 4 women have filed civil lawsuits against Warner. In the complaint, Warner alleges that some of the purportedly false statements made to prospective accusers have since been repeated by those accusers in court filings. The complaint also quotes directly from the civil lawsuits filed against Warner. Statements made in connection with civil litigation are protected activity. But okay, that's probably why those individual other women are not named as defendants here. What they say in their litigation doesn't protect Evan Rachel Wood for what she said to them. If they were repeated by them in their litigation, that would be a reason for them to claim litigation privilege, or that for them to claim that those statements are protected by, or that their conduct, those statements that they made, are protected by the anti-SLAPP law. But Evan doesn't get to claim that secondhand just because they also used it in their own litigation. Yeah. Yeah, I don't think that this argument is particularly persuasive either. They could almost maybe get there if they tried to say that her statements to them were in furtherance of their litigation. But that's not what she says here. All she says is it's made in connection with their civil litigation, just because they repeated those statements. Yeah. Also, yeah, Johnny's girl is an ERW celebrity too. Yes. That's probably all the more reason why that if anything, that pushes it more towards their issues being public interest as opposed to private. That's not dispositive, right? So like the fact that she's a public figure, he's a public figure, is not like automatically everything about their lives is public interest. But there's a lot of leeway there as soon as you become a public figure. Okay. Part B, Warner cannot establish a probability of prevailing on his claim. Now they're addressing prong 2 for this. They said because the IIED claim arises from protected activity, the burden shifts to Warner to demonstrate a probability of prevailing on the merits. Warner cannot do this. So once again, they have to go through all of the 4 elements of the cause of action. And they have to say why it's basically impossible. Their point has to be that it is impossible for Warner to prove his claim. First, Wood has never pressured anyone to make false accusations against Warner or to be part of the Phoenix Rising documentary. Rather, after Wood testified before Congress, Wood was contacted by other women who claimed to have experienced similar abuse by Warner. Some of Warner's victims met in 2020 to discuss their experiences, and portions of that meeting were filmed for Phoenix Rising. Notably, however, some victims who attended that meeting declined to appear in the film. Their wishes were respected. Thus, Warner cannot show outrageous conduct by Wood based on her communications with other victims. See Comstock v. Aber, where it says plaintiff alleging that defendant made false reports of sexual assault did not demonstrate outrageous conduct. Okay, but so she's saying that she was contacted by other women. However, I do know that there are other women who have said that they were contacted by Evan Rachel Wood or Illma Gore for the same purposes to participate. So there's at least 1 or 2, right? Like there at least have been a couple of them. In which case, we've got some disputed facts here. If he can show any amount of gray area of Evan Rachel Wood pressuring anyone to make false accusations against him, then he defeats her as to this element. And it would be his burden to show it, but he just has to show a chinchilla. Okay, moving on to the second element. Second, Warner cannot identify any false statement of fact made by Wood to any of the other victims, and therefore Warner's IIED claim based on Wood's communications with other victims is barred by the First Amendment. See, Lamb, public figure may not recover for IIED based on exercise of free speech without showing a false statement of fact. Possibly. Let me read this again. Warner cannot identify any false statement of fact made by Wood to any of the other victims. I mean, if they're going to say that, though, he's got to be able to probe that. And if he can show, like I said, if he can show that there is a way that the jury would interpret evidence in his favor, that there was a false statement of fact involved in their statements. I don't know. This is a little bit of a thin analysis for this point, but it doesn't really say to me that this is that she's going to win on this one, because of the fact that she doesn't really flesh out what exactly it is that she's saying. Again, if he can find some evidence in his favor, that's it. Okay. Third, Warner cannot meet his burden to prove severe emotional distress that was directly or proximately caused by Wood's communications with other victims. They don't say why. I mean, other than to point to the earlier points, but their earlier point about him not being able to prove severe emotional distress, I wasn't convinced by. So I guess I take the same analysis and put it here, since that's they basically are just using the same analysis here. Finally, Warner's claim is barred by the common interest privilege. And then it cites to Civil Code Section 47C. The common interest privilege applies to a communication made without malice to a person interested in the communication's subject matter by another person also interested in the communication's subject matter. Here, the communications among Warner's victims were made without malice among those with a common interest, processing the abuse inflicted by Warner. Thus, the IIED claim based on those communications is barred. That's her side of the story, though. If that is disputed, and he can show that with some facts to back it up, he could possibly defeat that. But it could be that this could be a nail on her side. So, and then it cites to Hasimovich v. Encinal School PTO, saying claims based on communications about the youth coach were barred. And then it cites to Terry again, saying IIED claim based on communications about plaintiff's inappropriate relationship with a minor was barred. However, arguably, the communications that were made in the group meeting that were filmed for the purpose of a documentary would fall outside of that, though. Right? Because they were filmed for the purpose of viewing, not just with those women, but with the public at large on HBO and elsewhere. So that puts those statements outside of that small group. It's not like communications about a youth coach by other people involved in a youth baseball organization or what have you, with the same sort of interests. Yeah, that kind of defeats that, I think, in my opinion. Part 6, the claims based on alleged defamation should be stricken. Part A, Warner's claims arise from protected activity. So remember, his claims about the defamation per se have to do with the statements about the groupie video. Those statements, he says, were made by Illma Gore, and then he basically says that Evan Rachel Wood consented to her statements, more or less. So here she says, Warner asserts an IIED claim based on Wood and Gore purportedly making knowingly false and defamatory statements against Warner, including that the actress in the groupie video was a minor and that Warner was manufacturing child's, let's say, illicit materials. Warner also asserts a cause of action for defamation per se based on Gore's statements about groupie. Like Wood's communications with other victims, Gore's statements concern a matter of public interest and are protected activity because they were made in connection with legislative reforms, criminal investigations, and civil litigation, and because they concern abusive conduct by a public figure. It's not clear to me how Gore's statements concern a matter of protected activity because they were made in connection with legislative reforms or criminal investigations or civil litigation. It's not immediately apparent to me. It could be the case that there's more context there that I'm just not aware of. But it's not apparent to me just based on the facts that have been alleged so far between the complaint and this particular motion. In fact, the safety of minors is a textbook example of a matter of public interest. And then it cites to Cross again, saying, preventing child sexual abuse and protecting children from sexual predators are issues of widespread public interest. And then Terry again, protection of children in church youth programs is an issue of public interest. MG says to MG, saying child molestation in youth sports is significant and of public interest. Yes, but just straight out making a a false criminal accusation about him possibly being indicted for a felony of something is different, though. My guess is that in response, Brian Warner's side is probably going to distinguish all of these cases from this particular instance. And as I said before, like I said, where somebody makes a false criminal accusation, those are not constitutionally protected. And there is California case law that supports that. Part B, Warner cannot establish a probability of prevailing on his claims. Okay, so they say Warner cannot establish a probability of prevailing on his claims against Wood because 1, there's no evidence that Wood made false statements about Groupie or conspired with Gore to make any such statements, and 2, Warner cannot meet his burden to demonstrate actual malice. So this is actually probably one of the stronger parts of this motion, in my opinion, because I remarked when I was going through the defamation per se claims in the in the complaint, I remarked that basically that entire section on defamation per se was all about Illma Gore. And then it just sort of like referenced Wood at the very end, saying that she had like consented to the statements or something like that, which in my opinion is probably not enough to assert a cause of action for defamation per se against an individual. Like you can't, like if somebody else makes a statement standing next to you and you say, yeah, thumbs up or whatever, you haven't necessarily defamed that person. The other person maybe has, but just by standing there with like a thumbs up doesn't necessarily mean that you are republishing that same statement. So I don't know that he actually has alleged enough in that defamation per se to successfully allege that against Evan Rachel Wood. Illma Gore, on the other hand, is a different story. Okay, but anyway, let's continue on to see what she says here. Warner cannot sue Wood for defamation based on statements that Wood did not make. Usually that is true, unless there is some sort of vicarious liability that is alleged, which in the complaint, there actually wasn't an allegation of vicarious liability as to those statements. The complaint does not allege that Wood made false statements about Groupie, nor has Warner identified any other specific statement by Wood that Warner contends forms the basis of his defamation-based claims. Absent a false statement of fact by Wood, Warner's defamation per se claim and associated IIED claim must be stricken. She might actually win on this one, I will say. Moreover, Warner cannot demonstrate that Wood acted with actual malice when Gore allegedly made false statements about Groupie. Public figures may not recover for the tort of intentional infliction of emotional distress by reasons of publications without showing, in addition, that the publication contains a false statement of fact, which was made with actual malice, i.e., with knowledge that the statement was false or with reckless disregard as to whether or not it was true. So we are very familiar on this channel with the definition of actual malice, right? If you've been following any of the videos from this channel from the last like several months, you know actual malice by now, right? Citing to Hustler Magazine Inc. v. Falwell, very, very prominent case in this area. In the context of an anti-SLAPP motion, a public figure suing for defamation must establish a probability that he will be able to produce clear and convincing evidence of actual malice. Citing to Annette F., which says the clear and convincing standard requires that the evidence be such as to command the unhesitating assent of every reasonable mind. Oops. The crucial issue is the defendant's actual belief concerning the truthfulness of the publication, not the defendant's attitude towards the plaintiff. Warner cannot meet this burden. The statements at issue are that the actress in Groupie was a minor and is dead. Warner contends that these statements were meant to implicate Warner in child illicit material, alleging that Gore stated that Groupie was evidence of a felony and that Warner would be indicted as a result. Warner cannot meet his burden to produce clear and convincing evidence that Wood knew the alleged statements were false. Indeed, in January 2002, Warner himself publicly bragged that when he showed Groupie to his manager said, "Please hide the masters. If anyone sees this, you'll go to jail and your career will be over." That could also be, I mean, there are multiple ways of interpreting. This was in the declaration. The full context of that conversation was in the declaration. When I saw that, I was like, that can be interpreted in a number of ways. Basically, to say that it looks convincing to someone that she would be underage doesn't necessarily mean that she was in fact underage. But also, Evan Rachel Wood could have been privy to other conversations with other people. She may have known who that particular actress is, in which case she could see what her birth date was. My understanding is that she was in her 20s during the filming of it and that she is still alive. She actually signed a declaration recently, which I think is indication enough that she is, in fact, alive. But so, you know, the statements here, I think there's arguably enough there to say that those statements, if those were made by Illma Gore, were false statements. If there's a good way for her to know who Paula Weiss is, and find information about her, then that could be relevant information. It could also be that Evan Rachel Wood just knew through being around, through being around Marilyn Manson over the years. She might know the story of the Groupie video, regardless of what he said in some interview about the video later on. In that same discussion, Warner joked that the actress may have been under 18, and Andy Dick claimed that people start bleeding at some point. This is having read the declaration where she cites to it, that she's citing to, that's a weird compiling of two different statements, because there's like several different things that they say in conversation. That's a little bit misleading, the way that these two conversational points are grouped together in that particular sentence, I will say. But they are trying to frame it as positively for their client as possible. Going back to the motion, moreover, in a publicly filed complaint, one of Warner's victims has alleged that Warner made her watch Groupie, that the actress looked like a young teenager, and that she repeatedly asked Warner if the girl in the video was dead, but that Warner would not answer. Nor would this be the only time Warner has been accused of child abuse. In light of these facts, Warner cannot demonstrate by clear and convincing evidence that Wood did not believe Gore's alleged statements to be true when they were purportedly made. He could find other he can find other evidence elsewhere, other circumstantial evidence that shows that she did know. Just because she, like I said, just because she says that she didn't know doesn't necessarily mean that he can't prove otherwise. He can use other evidence. He can use conversations that she's had with other people where she's admitted otherwise, etc., etc. There are ways of showing that. Now, I will say, however, that facially, he probably has some issues as to the defamation per se claim as against Evan Rachel Wood. She might be able to get herself dismissed from that specific claim and from the IIED claim as that is alleging the defamation per se claim against her. But that would still possibly keep it for his claim against Illma Gore. It wouldn't necessarily be fatal to his case. Okay. Wood is entitled to attorney's fees and costs. A prevailing defendant on a special motion to strike shall be entitled to recover his or her attorney's fees and costs, blah, blah, blah. Basically saying that if she wins, she gets her reasonable attorney's fees paid for in preparation, whatever she has had to pay in preparation for this particular motion. And then for the foregoing reasons, would respectfully request that the court grant her motion. Okay. That's what all of this is, blah, blah, blah. Okay. I'm going to turn to the other anti-SLAPP motion, but first we've got some super chats here. Tracy Fagan, thanks so much for the $5 super chat. She says she thought it was real. How about FBI letterhead? Is she playing dumb blonde? That's one reason why an argument can be made that he could prove that she was lying about the FBI letterhead, that he could prove that the statements that she made in that document were defamatory, right? And that or that she was, intentionally inflicting emotional distress by using that letter. That's circumstantial evidence that could be used to help prove his side of things. Colonel Kurtz, thanks so much for the super chat. Says, thanks for your coverage, everyone. It's going to be a long and sometimes bumpy road. No need to get anxious, even though I know some of us have big views. Yeah, for sure. I mean, this is early days in this litigation. We're working our way through this. I know I'm working my way relatively slowly through this. Colonel Kurtz has made her opinions known on this particular case. I know that there are folks in the chat that believe Evan Rachel Wood. There are those in the chat that believe Marilyn Manson. Like I said, I am slowly making my way through this particular case, going through the specific arguments, and so far, my impression of the anti-SLAPP motion filed by Evan Rachel Wood, I'm not convinced that she's going to be winning this one. Because although some of her arguments, she might be able to show that first prong, saying that certain activities are that they fall under the umbrella of constitutional activity. At the same time, her arguments for why she thinks that he cannot prove his the probability of his case. I'm not particularly convinced. I think that there are ways of him potentially showing that. So, but we'll see as this continues. Uncivil law, thanks so much for the super chat. Says actual malice is where you just don't like someone. That's not true, and you know it. Of course, like I said before, and as was stated in Evan Rachel Wood's motion, actual malice is where somebody makes a false statement, either knowing that it's false or with reckless disregard as to the truth or falsity of the statement. So, but I know you're just cracking jokes. And T in Tennessee, thanks so much for the super chat, says, and then there are those in the chat who genuinely have no clue. Yeah, welcome. We bring all types here, and we are we're all making our way through this at different levels, right? But I welcome people of all opinions, all persuasions, or no opinions at all to go through this particular case. But thanks so much for the super chat, T in Tennessee. Okay, now let's turn to Indy getting comfortable. Hi, puppers. Hi, puppy. Love you, okay. Okay. So let's, but enough of that. She's like, get on with it so that we can go rest. Let's turn to the other motion for anti-SLAPP. This one was filed by Ashley Gore, aka Illma Gore. So technically she filed two documents. One of them was the actual motion document. And then this is the memorandum of points and authorities. Evan Rachel Wood had filed them together in one document. Okay. So her basic arguments are along similar lines. So her relevant factual background and allegations. We'll go through this first real quick, and then we'll go through the actual document. Okay. First, the complaint acknowledges Gore's petitioning activity, speech on matters of public interest, and involvement with law enforcement investigations regarding allegations of abuse. 1. Gore worked with Wood to advocate for extension of the statute of limitations for abuse victims and to organize and support victims through the Phoenix Act. 2. Gore worked to assist victims of domestic violence and abuse in court, including Warner's victims. 3. Gore worked with Wood to bring victims' stories to light in connection with the documentary film Phoenix Rising. 4. Gore and Wood worked with law enforcement investigations regarding allegations by victims. B. Warner files a complaint against Gore and Wood based on their petitioning activity, speech on matters of public interest, and involvement with law enforcement investigations regarding allegations of abuse. One, Warner alleges intentional infliction of emotional distress based on Gore's alleged statements related to his groupie video and on her communications with his victims. 2, Warner alleges defamation per se, public figure based on Gore's alleged statements related. So basically, what she's going to be getting into is, again, the groupie video and the communications with the other woman. Okay, and then she gets into her legal argument. 3 main points. A, the anti-SLAPP statute gives broad protection to free speech and petitioning rights. That is true. B, Warner's claim for intentional infliction of emotional distress based on Gore's alleged statements related to his groupie video and on her communications with victims should be stricken. For these reasons, first, Manson's IIED claim arises from Gore's exercise of free speech and her participation in law enforcement investigations. Interesting. And 2, Manson cannot establish the merits of the IIED claim. C, okay, and then her third point as to for anti-SLAPP is Warner's claim for defamation per se, public figure, should be stricken because it arises from protected activity. The defamation per se claim arises from Gore's communications concerning a matter of public interest, and then Manson cannot establish the merits of defamation per se claim. Okay. All right. Let's get into it. All right, page 1 here. All right, introduction. Brian Warner, famously known as Marilyn Manson, filed this action just 2 weeks before the documentary Phoenix Rising aired. The timing was no accident. The complaint is a classic example of an anti-SLAPP suit seeking to punish defendants Evan Rachel Wood and Ashley Gore for their petitioning activity, free speech in connection with a matter of public interest, sexual abuse, through the documentary and their communications with Manson's other accusers, and work with law enforcement in the ongoing investigation into Warner. Warner's suit attempts to discredit and intimidate Wood and Gore and to silence the dozens of women he has victimized. Many of the allegations of the complaint, all incorporated by reference into the intentional infliction of emotional distress and defamation per se claims, allege protected activity satisfying the first prong of the anti-SLAPP statute. Warner cannot establish the merits of these claims, in large part because they parallel statements he himself has made about the film Groupie, addressing the defamation per se claim, and about his sexual activities. Nor can he show that Gore acted with the requisite malice necessary for a public figure to assert a defamation claim. The allegations arising from protected activity should be stricken, and Gore awarded her attorney's fees incurred in connection with this motion. Okay. 2, relevant factual background and allegations. A, the complaint acknowledges Gore's petitioning activities, speech on matters of public interest, and involvement with law enforcement investigations regarding allegations of abuse. And first, she says Gore worked with Wood to advocate for extension of the statute of limitations for abuse victims and to organize and support victims through the Phoenix Act. Warner alleges that Wood incorporated the Phoenix Act the day before her April 2019 testimony to the California State Senate. Warner alleges that Gore worked for the Phoenix Act since 2019. The Phoenix Act describes itself as a survivor-led nonprofit created by Evan Rachel Wood that works to end the cycle of domestic violence through organizing and passing legislation across the country. Warner alleges that Gore and Wood's work in connection with the Phoenix Act continued through at least November 2021. Warner alleges that Wood's sworn testimony in February 2018 and in April 2019 before the U.S. Congress and the California State Senate was given in support of the proposed legislation with which she, Gore, and the Phoenix Act were affiliated, seeking to extend the statute of limitations for abuse victims. Wood testified that she had been AR'd by a significant other who she later identified as Warner. Okay. Part 2. Gore worked to assist victims of domestic violence and abuse, including Warner's victims. Warner alleges that Gore and Wood have communicated with individuals who accused Warner of R and abuse over the past 10 or more years, independently and in connection with the Phoenix Rising documentary. As the article cited in footnote 27 of the complaint discusses, numerous women have accused Warner of abuse over the course of many years, and Warner himself has bragged of R-ing and abusing women. So, and a lot of these citations that I'm sort of glossing over are these are requests for judicial notice. How she's trying to have, she's also requesting that the court judicially notice the existence of like the Rolling Stone article. There are certain requirements for granting judicial notice. Basically, what it means is that this is something that does not become disputed. It depends on what exactly she's trying to get the article in for, I think. But as an example, something that can be judicially noticed is the time of sunset on January 25th, 2020, right? Because like that's something that like everyone can actually agree upon so that you don't have to have the parties like actually arguing over throughout the litigation. So, anyway, so I'm sort of glossing over those. That's another analysis that could be for another day, possibly, if it's interesting enough. Okay. Okay. Through the Phoenix Act, in connection with the film project, Gore and Wood organized meetings where prospective accusers could meet and share their stories, despite the abuse having caused some of them to repress their memories for years. And I still have to have a video talking about that with a psychologist or a psychiatrist, someone talking about repression of memories. But interesting. I'm very interested in digging into that, like I've said before. Part 3. Gore worked with Wood to bring victim stories to light in connection with the documentary film Phoenix Rising. In 2019, Wood and Gore began working on a documentary film project, to chronicle Wood's activities on behalf of the Phoenix Act, titled Phoenix Rising, in conjunction with HBO. On February 1st, 2021, after working with other women who accused Warner of abuse, Wood posted on her Instagram page that it was Warner who had abused her. That same day, several other women made similar public abuse allegations against Warner. Some of these women's stories of abuse by Warner became part of the HBO documentary. The complaint alleges that Gore and Wood are prominently featured and heroically depicted in the documentary. Wood's public allegations against Warner are seen to corroborate her prior statements and testimony. Sorry, guys. Let me read that again. Wood's public allegations against Warner were seen to corroborate her prior statements and testimony that she had been abused by a significant other. And in turn, it looks like it says in tum. I think it's supposed to say in turn. The public allegations by several other women were seen to corroborate Wood's allegations. Part 4. Gore and Wood worked with law enforcement investigations regarding allegations by victims. Phoenix Rising documents Gore's efforts to amass evidence for an ongoing criminal investigation of Warner and provided such evidence to law enforcement, including compiling and organizing information from allegations, including those made publicly by Warner's victims. Okay. But like I said before, I'm wondering why Wood and Gore would be the ones to be compiling information as opposed to just giving the contact information for LA County sheriffs or the FBI to compile that themselves. Okay. It does cite to the request for judicial notice saying Warner's home was raided by the LA County Sheriff in November 2021 in connection with sexual assault investigation. In the past year, 5 civil actions have been filed against Warner alleging abuse. Okay. Part B, Warner files a complaint against Gore and Wood based on their petitioning activity, speech on matters of public interest, and involvement with law enforcement investigations regarding allegations of abuse. I mean, that's her phrasing of how of what he based his complaint off of. He would never frame it as he's basing his defamation and IIED causes of action on their petitioning activity, right? Because that would be facially bad for him. Okay, part 1. Warner alleges intentional infliction of emotional distress based on Gore's alleged statements related to his groupie video and her communications with his victims. In support of Warner's first cause of action for intentional infliction of emotional distress, incorporates the preceding allegations by reference, the majority of which, sorry, that phrasing is grammatically weird. It caught me off guard. The majority of which reference protected activity and further accuse Gore of making knowingly false and defamatory statements against Warner, including that the actress in the groupie video was a minor and that Warner was manufacturing youth illicit material. And 2, recruiting, coordinating, and pressuring multiple women to make false accusations against Warner and to be part of their film project. 2, Warner alleges defamation per se, public figure, based on Gore's alleged statements related to his groupie video. In support of his second cause of action for defamation per se, Warner alleges Gore stated to persons other than Warner that during the filming of Groupie, the actress in the video was a minor and that the actress was dead. Gore understood the statements to refer to Warner and specifically to mean that Warner's role in the making of Groupie, e.g., as a youth illicit material, was criminal. Indeed, that she stated that Groupie was evidence of a felony and that Warner would be indicted as a result. On information and belief, Gore knew the statements were false or had serious doubts as to their truth. Upon information and belief, Gore knew the actress was not a minor or had serious doubts that she was a minor, but instead intended to peddle these false and defamatory statements because Warner's alleged abuse of others, including as reflected on the checklist provided to women that Gore recruited to come out against Warner. Gore made the above described false and defamatory statements without privilege or justification. These allegations on which Warner's IIED and defamation claims are based arise from protected activity and are therefore susceptible to the anti-SLAPP motion. All right, let's see why. Let's see why she says that they're susceptible to the anti-SLAPP motion. Okay, legal argument. The anti-SLAPP statute gives broad protection to free speech and petitioning rights. I'm not going to go into the legal standard again for anti-SLAPP because I've already been basically through it twice in my initial intro, and then now and then recently in Evan Rachel Wood's motion. So I'm going to skip through this portion here because it basically says the same thing. Okay. B, Warner's claim for intentional infliction of emotional distress based on Gore's alleged statements related to his groupie video and on her communications with victims should be stricken. Why should they be stricken, you ask? Let's continue and find out. 1, Manson's IIED claim arises from Gore's exercise of free speech and her participation in law enforcement investigations. As noted above, in support of Warner's first cause of action for intentional infliction of emotional distress, he alleges that Gore engaged in 2 categories of protected activity. I mean, he doesn't allege that she engaged in protected activity. So that's a little bit of a misstatement here. But the court arguably will be able, I mean, that the reader here, the intended audience of this motion is the court, the judge. So they'll be able to see through that. It's not exactly for public consumption necessarily, although they probably understand that people are going to be looking at it like me. Okay, first, Warner accuses Gore of making knowingly false and defamatory statements against Warner, including that the actress in the groupie video was a minor and that Warner was manufacturing youth illicit material. This allegation implicates Gore's exercise of free speech in connection with a public issue or an issue of public interest. Protecting people from sex offenders is a matter of public interest. Moreover, the issue of child molestation in particular is a matter of public interest. Yeah, but you're talking about something that had happened how many decades before? And what is the context in which those statements were made? Were the statements made by Illma Gore? Were those made in the context of talking to someone who has children that they have around Marilyn Manson? Possibly. Then there could be a viable argument here. But if it's just they're at a party and she's talking smack about him, that it doesn't necessarily implicate this particular public interest. Also, as I mentioned before, courts have said that causes of action arising out of a false allegation of criminal conduct is not subject to an anti-SLAPP. And that's because making a false allegation of criminal conduct is not an act in furtherance of the constitutional right of petitioning or free speech, according to California appellate case law. Okay. Second, Warner accused Gore of recruiting, coordinating, and pressuring multiple women to make false accusations against Warner and to be a part of their film project. This claim arises from protected activity for a number of reasons. These communications with Warner's victims and related activities were made in a public forum in connection with an issue of public interest and or constitute any other conduct in furtherance of the exercise of the constitutional right of petition or free speech in connection with a public issue or an issue of public interest. The accusations Warner references are statements made by victims accusing Warner of domestic violence and abuse. Furthermore, these statements were made on social media and press interviews and in survivors' meetings filmed for Phoenix Rising. This is almost verbatim what Evan Rachel Wood said on this point. And so my thoughts on this are exactly what they were as to Evan Rachel Wood's motion. Courts have consistently held that communications regarding domestic violence and sexual abuse are a matter of public interest. Okay, citing the same cases as before. Moreover, contrary to Warner's claims that Gore and Wood fabricated the existence of an investigation, it is public knowledge that Warner's home was raided by the LA County Sheriff's Department in November 2021 when they executed a search warrant in connection with an ongoing investigation. Statements in anticipation of or in connection with a criminal investigation are protected activity. Okay, maybe. Possibility on that one. Maybe. Finally, all activity in connection with Woods and Gore's film project, Phoenix Rising, is absolutely protected free speech. A documentary film on a matter of public interest, such as abuse and domestic violence, is protected activity for purposes of the anti-SLAPP statute, citing to O.J. v. Brown. Interesting. I want to look up this particular case because Okay. Furthermore, an act is in furtherance of the right of free speech if the act helps to advance that right or assists in the exercise of that right. It goes without saying that in order to produce a documentary, a filmmaker must obtain footage and collect information on the subject matter. Thus, defendants maintaining an online journal of refugees' stories to gather ideas for the production are reasonably viewed as conduct in furtherance of the documentary. They might have a point there. This might actually satisfy the first prong. They still would have to satisfy the second prong. As in OJ, all activity related to Phoenix Rising, including Gore's communications with individuals who accuse Manson of abuse, is absolutely protected speech and triggers application of the anti-SLAPP statute. So then, if that's the case, Manson has to show that he has a probability of prevailing on the claims. 2, Manson cannot establish the merits of the IIED claim. So this is why they say that he can't do precisely that, right? So I said he's got it. He would have to show a probability that he'll prevail, and they say these are the reasons why he wouldn't. So let's dig into the details. A defendant asserting an anti-SLAPP motion need only establish a prima facie case that his alleged actions fell into one of the categories listed in section 425.16. Because the IIED claim arises from protected activity, the burden shifts to Warner to demonstrate a probability of prevailing on the merits. Warner cannot do so. Also, T in Tennessee, thanks so much for gifting 5 memberships to folks in the chat. Thank you. That was so kind of you. Very, very kind of you. I really appreciate your generosity. Thank you. And guys, welcome to Bike Club. To the new members. I wish that I could highlight it on the screen, but for whatever reason, StreamYard does not allow me to do it for that specific action. So there are some things that StreamYard doesn't quite do very well. But yeah, T in Tennessee kicks ass. Thank you so much. Very, very kind of you. Alrighty. So they say because the IIED claim arises from protected activity, the burden shifts to Warner to demonstrate a probability of prevailing on the merits. Warner cannot do so. Okay. The elements of a claim for IIED are, once again, we'll do it real quick. First, outrageous conduct by the defendant. Second, intention to cause a reckless disregard of the probability of causing emotional distress. 3, severe emotional suffering. 4, actual and proximate causation of the emotional distress. So the 4 elements. A plaintiff must demonstrate that the claim is both legally sufficient and supported by a sufficient prima facie showing of facts to sustain a favorable judgment if the evidence submitted by the plaintiff is credited. So they have to make a prima facie showing, meaning that he doesn't have to prove his entire case at this early stage. He just has to show enough to get over the hurdle. They say the plaintiff cannot do so here. The knowingly false and defamatory statements against Warner, including that the actress is in the groupie video, was a minor, and that Warner was manufacturing child illicit material, allegedly made by Ms. Gore, cannot be outrageous conduct as they virtually repeat comments made by Warner himself, including 1, in response to a comment from another person that an actress portrayed in the film was 18 years old. Less, more, I don't know. 2, it wasn't just horseplay. 3, I introduced a gun into the situation and it becomes really scary. And 4, when I showed it to my manager, he said, please hide the masters. If anyone sees this, you'll go to jail and your career will be over. What she's referring to is, again, this interview with Andy Dick, which maybe it's worth going through that at some point. Probably not today, since this video is already going a bit long. But Evan Rachel Wood's motion also referred to this Marilyn Manson Dinner for Five episode where he's describing the filming of the groupie video to Andy Dick. They're kind of talking through the whole thing. so she's making a lot of emphasis on him saying less, more, I don't know. He is like basically suggesting here maybe she was under 18. But the thing is, in that same conversation, he then later says, no, she definitely was over 18. Unless I'm remembering it incorrectly. But if I remember correctly, when I was reading through that conversation, he says, yeah, less, more, I don't know. And then just to get their reaction is like, whoa, wait, what? And then he's like, no, she definitely was over 18. And then his whole point here is that this was essentially a prank on the other people. They don't know that this is all false, that she's an actress while they are filming it. His other friends and whatnot that are part of this video. And so it becomes really scary to other people in the room when he starts to sort of escalate the things that are happening in this video as he described it. Again, if I'm remembering it correctly. And then when I showed it to my manager, he said, please hide the masters. If anyone sees this, you'll go to jail. Your career will be over. That could also be hyperbolic statements. This is also Marilyn Manson recounting what his manager supposedly said to him. So he may be exaggerating what his manager actually said to him. This is just, I'm looking at this with a devil's advocate sort of perspective. So her virtually repeating comments made by Warner himself, I'm not entirely convinced by that. Having looked at this conversation from Dinner for Five, and by the way, this link right here in blue, anyone can click on that and see the transcript of that episode of Dinner for Five. So you can read exactly what I'm talking about here. And the fact that she said, the fact that he makes these kind of comments that are shocking or whatnot, doesn't necessarily mean that he cannot prove that what she said was outrageous conduct. In order for it to be outrageous, the conduct has to be something that someone objectively would be looking at that and saying, that's not something that we want someone saying in a civilized society or doing in a civilized society, right? So like, something that could be objectively outrageous would be, someone improperly handling the remains of someone who died, right? And doing so in a way that is mocking. That would be pretty patently outrageous. That's an example, right? That we can all probably mostly agree that would be the case. There's a subjective and an objective standard. And she doesn't address the objective standard at all here. So I'm not entirely convinced by this argument so far. But then again, she does go on. So let's see what else she says here. Okay, so she cites to this MansonWiki.com about the Manson Dinner for Five, which includes a transcript of Mr. Warner's 2002 statements about Groupie on Dinner for Five, the relevant portions of which are highlighted. Okay, so she attaches it in her request for judicial notice. Okay. Webpage stating Manson manager Tony, is it Chula? I'm sorry if I'm mispronouncing it. Begged Manson to prevent the public distribution of public viewing of Groupie, citing fears that it would be considered sufficient evidence to convict Manson if a criminal case was ever brought against him. The context of this, arguably, is, Marilyn Manson has found himself in the crosshairs of public persecution, one could argue, for things that he was not arguably responsible for. Columbine is a clear example about that. Anyway, Statements allegedly made by Ms. Gore are essentially Warner's own words, and further, as discussed above, protecting people from sex offenders and the issue of child molestation in particular being a matter of public interest, the statements cannot be outrageous. Them being essentially Warner's own words, but they're not exactly. Context is key, right? There are certain contextual cues that make it different than what he said. Protecting people from sex offenders and the issue of child molestation in particular being a matter of public interest. This is not really relevant for determining whether or not her statement is outrageous. Because like I said, there's a particular objective standard that she's not addressing here. So I'm not finding this argument very convincing so far. Nor is there any indication Warner could prove 2, intention to cause or reckless disregard for the probability of causing emotional distress, 3, severe emotional suffering, and 4, actual and proximate causation of the emotional distress. Why? Why do you say that? What's your argument for that? Just because you say that there's no indication doesn't mean that he cannot prove it. Why do you say that he cannot prove it? Similarly, with respect to the allegations of recruiting, coordinating, and pressuring, sorry, let me save this. Thanks for the super chat, Kurt. I'll get to it in a sec. Similarly, with respect to the allegations of recruiting, coordinating, and pressuring multiple women to make false accusations against Warner and to be part of their film project, Warner cannot show outrageous conduct by Gore based on her communications with other victims. See, Comstock, where they say plaintiff alleging that defendant made false reports of sexual assault did not demonstrate outrageous conduct. If false reports of sexual assault is different than recruiting, coordinating, and pressuring multiple women, though. That I don't think that this law that has been cited here doesn't exactly support what they're saying that it supports. Okay. Warner cannot identify any false statement of fact made by Gore to any of the other victims, and therefore Warner's IIED claim based on Gore's communications with other victims is barred by the First Amendment. But why do you say he cannot? Is it just your belief that that's not true? Because the fact is, there's a possibility that he could pull some sort of evidence from somewhere to circumstantially show the falsity of that statement, regardless of whether or not Illma Gore believes that it is true or false. Nor is there any indication Warner could prove 2, intention to cause or reckless disregard of probability of causing emotional distress, 3, severe emotional suffering, and 4, actual and proximate causation of the emotional distress. This is, again, nor is there any indication. It's the same thing that she kind of says before. She's sort of like phoning in this argument by not really fleshing out why she says it. So I'm not really particularly convinced by her arguments here. Finally, as Warner admits in his complaint, Wood made it clear in Phoenix Rising that the film itself, which followed her and Gore's work to help Warner's victims, isn't about revenge. Well, he doesn't admit that. He says that Evan Rachel Wood said that. That's a different. That's misstating what his allegations are in his complaint. And that for me as a litigator always really annoys me. When someone misstates what has been alleged or what has been claimed or what has been admitted. For me, it's a pet peeve because this is showing that someone is trying to sort of hide something under the table. And you can win an argument in litigation. You don't have to resort to tactics of trying to pull the wool over someone's eyes. So things like this, it might seem a little ticky-tacky, but this starts to perk up my antennas as to Illma Gore's attorneys here and their drafting and whether or not I trust the citations that they're pointing to, the the ways in which they're characterizing what other people have alleged and other people have said. So far, I don't really like that coming out of this particular motion. Part C, Warner's claim for defamation per se should be stricken because it arises from protected activity. Part 1, defamation per se claim arises from Gore's communications concerning a matter of public interest. The activity alleged here is almost identical to the first set of alleged conduct supporting Warner's claim for IIED. This allegation similarly implicates Gore's exercise of free speech in connection with a public issue or an issue of public interest in protecting from sex offenders, and the issue of child molestation in particular being a matter of public interest. Okay. 2, Manson cannot establish the merits of the defamation per se claim. Okay. I mean, so basically what she's saying here is that she's just restating her argument earlier for the defamation per se as to, like she said, I mean, because she referenced it. She talked about it in the IIED section. That's fine. So same analysis there. 2, Manson cannot establish the merits of the defamation per se claim. Because the statements Warner complains of are protected activity for the reasons discussed above, the burden shifts to Warner to demonstrate a probability of prevailing on the merits. Warner cannot do so. The elements of defamation claim are 1, a publication that is 2, false, 3, defamatory, 4, unprivileged, and 5, has natural tendency to injure or cause special damage. A plaintiff who is a public figure, however, must prove more. That is true. Warner is an all-purpose public figure as someone who has achieved such pervasive fame or notoriety that he or she becomes a public figure for all purposes and in all contexts. Yeah, that's probably true. When a defamation action is brought by a public figure, the plaintiff, in order to recover damages, must show that the defendant acted with actual malice in publishing the defamatory communication. Furthermore, Warner must prove actual malice by clear and convincing evidence standard to prove actual malice in a defamation claim. All of that is so far correct. As set out in section 3B2 above, the statements allegedly made by Ms. Gore are essentially Warner's own words, so she would have no reason to believe they were false or that he would be injured by them. In fact, in addition to his statements at the Dinner for Five episode, there are numerous examples online about Warner and his entourage engaging in sexual and violent acts with minors, making it impossible for him to show that a virtual repetition of his own words, apparently in private, had a tendency to cause him injury or damage. That doesn't mean that he cannot make a prima facie showing of those 5 elements for defamation. In other words, just because she's saying this here doesn't mean that he can't show through circumstantial evidence, right? Like he would be expected, or she would be expected, I should say, in this case, Illma Gore would be expected to basically say exactly that, to say, nope, what I said wasn't false, or at least I didn't think it was false. I had every reason to believe it wasn't false. But if there is evidence elsewhere that Brian Warner can pull to show through circumstantial evidence that there's no way that she's telling the truth there when she says that, that's evidence that can be used to prove his claim. So to say he cannot show it, if he can, I mean, it depends on what kind of a showing he can make here in response to this motion. If he can point to some evidence to show a chinchilla of evidence, then he can arguably defeat this motion. Okay, and then it goes into Gore is entitled to attorney's fees and costs once again. And then she says, in conclusion, the anti-SLAPP statute was enacted to prevent precisely this type of lawsuit. Warner should not be permitted to use the court system to intimidate and discredit those who have come forward against him and those like Gore who have assisted them. Okay, well, could be. We will see. I'm not particularly convinced that this is exactly the type of lawsuit that the statute was enacted to prevent. I don't think that they are likely to win on this motion or on the other one. Whether or not he is likely to win on the case in general is another question. That's a whole other analysis. going into the various claims by individuals, the statements, the the other conduct, all of that has to be looked at separately. But as for the anti-SLAPP motions, I'm not particularly convinced at this stage that they are likely to win, but it'll be interesting to see how Brian Warner is able to respond in his opposition. And as soon as that's filed, I will be very interested to see that. But that's not likely to happen for a while because of the motion for discovery requests, for limited discovery requests. Basically, what he's saying is, in order to respond to these motions, these anti-SLAPP motions, I need the opportunity to pull some evidence, to pull some information, because I have a burden of proving certain things, of making a certain level of a prima facie showing. So I should be allowed to get some more evidence from the other side in order to make that, which, generally speaking, I think that there's a good possibility that the court may side with him on that. But we'll go through that specific motion in another video. I went through the last week. I went through what is it called? I'm brain farting here after several hours of live streaming. I went through the ex parte application and whatnot, and the arguments that they went through before. But I do think that, generally speaking, where he has a particular burden that has been placed on him, he should be allowed to get some evidence to make a showing, where that is reasonably necessary in order to do it. So anyway, that is that. And let's go through some final super chats here. Wendy Pinkerton, thanks so much for your super chat. Says, thanks for your insight. Very helpful. Well, thank you for being here, for hanging out. Pearlin Toda says, I'm not sure what is going on. Just joined the stream at 2056 German time, but AH is evil. MM is fine. When does the prawn start? Executions at 2100. Well, we are not going to be starting the prawn at any point. But I do appreciate the super chat. Thank you for that. Uncivil Law, thanks so much for the super chat. Says, if you have never seen it, Marilyn Manson's interview with Bill O'Reilly on the O'Reilly Factor back in the day is worth a watch. We'll have to definitely check that out, because I get the sense from my memory that Bill O'Reilly was basically probably Marilyn Manson's arch nemesis at the time. I do remember something about an interview between the two of them, but I definitely need to go in and check that out for sure. Lena Palmquist, thanks so much for the super chat. Thank you. And finally, Pearlin Toda, Indy, 2 hours, 40 minutes in, the main star arrives. I know. She decided to switch from the floor to the chair, and then she'll go back to the floor again at some point, until eventually I go to bed, and then she joins me and Mr. Bites to crowd us out. So anyhow, okay. So those are my thoughts on the anti-SLAPP motions that have been filed so far. Like I said, I definitely will be very interested in covering the oppositions and then the replies, and then we'll be finding out what the court decides. But so far, I don't see this case going away because of these anti-SLAPP motions. Not particularly. Okay. Anyway, that for me about does it. I hope you guys have a wonderful rest of your day, wonderful rest of your week, if I don't see you until then. But I should be live streaming tomorrow. Tomorrow's a Thursday. It should be what is it? Ladies in the Law Day, as I normally have scheduled. So anyhow, I will see you guys